The Center for Continuing Education, CCE, is a State Bar of California MCLE approved provider. The Center for Continuing Education, CCE, presents Immigration Opportunities for the World's Top Athletes, Artists, Performers, and Scientists. Today's program features two highly respected San Francisco-based immigration law attorneys. James A. Bach has been working exclusively with immigration cases for several decades and has lectured and written extensively on immigration law subjects. Mr. Bach is one of less than 8% of California immigration attorneys certified by the State Bar of California Board of Legal Specialization as a certified specialist in immigration and nationality law. He has been given the highest AV rating by Martindale-Hubbell for ability and ethics for over a decade, and is included in the current Martindale-Hubbell Bar Register of Preeminent Lawyers. From 1987 to 1990, Mr. Bach was the head of the Immigration Law Department of Crosby, Heafy, Roach, and May, now Reed Smith. Currently, Mr. Bach serves as the chair of the State Bar's Immigration and Nationality Advisory Commission, which writes and grades the California Immigration and Nationality Specialty Examination. He is also an arbitrator for the San Francisco Bar Association. Robert G. Werner has been practicing immigration law in San Francisco since 1971. He received his A.B. from Harvard College, cum laude, in 1967, and his J.D. from the University of California at Berkeley in 1970, where he graduated in the top 10% of his class and was editor of the Law Review. Mr. Werner has been granted the highest Martindale-Hubbell AV preeminent rating for both legal ability and ethical standards. Mr. Werner has been certified as a legal specialist in immigration and nationality law by the State Bar of California Board of Legal Specialization for over 20 years. He was in the first group of immigration law specialists to be so certified. Mr. Werner serves on the California State Bar Immigration and Nationality Advisory Commission, helping to write and grade the immigration specialty exam. He has been designated a Northern California super lawyer in the field of immigration law by his peers.
Hello, our program today is Immigration Opportunities for the World's Top Athletes, Artists, Performers, and Scientists. My name is James Bach, and I'm joined today by Robert Werner. We're both employment immigration attorneys in San Francisco. I'm going to start with the advantages of what we call priority worker categories. There is no priority worker term in the regulations. That's something that we use as a shorthand to discuss alternatives to labor certification. And that could be either the extraordinary ability, exceptional ability workers for Schedule A Group 2, outstanding professors. These words, extraordinary, exceptional, outstanding, all have different meanings. They're different terms of art. If you go to Webster's dictionary, you'll find they pretty much mean the same thing, but when you deal with these concepts in the immigration context, they all mean different things. The reason we talk about priority worker categories, and the main reason that we use them, is to avoid labor certifications. So when you have one of these exceptional workers, you have to first look at all of these possibilities and opportunities. And keep in mind that even though the Immigration Service in its press releases, the public, Congress, anyone who talks about immigration policy will all pay lip service to the idea that we want to get the best and the brightest people into the United States, those people who can seriously benefit the economy, the science, and the art of the United States. But in practice, when we file these petitions, we get a lot of resistance from the USCIS. There's a lot of pushback on all of these categories, and the mindset seems to be, how do we deny the petition rather than how do we make it easy for these highly talented people to immigrate to the United States? So in looking at the various options and keeping in mind when you have, let's say, a very highly talented biochemist who's written articles, who's maybe written a book, who lectures at various conferences, and who's cited in many different types of publications. You first want to look at what is, not just what does this person qualify for, but what is the best strategy for getting this person a green card. And I would suggest that the first thing you want to look at is a labor certification. So these priority worker categories are all designed to avoid labor certification and maybe had more resonance and more utility 10 years ago when a labor certification could take 5 years or 3 years, or there were some cases taking more than 5 years. But now we can get a labor certification after we do all of the recruitment, sometimes in just a few months. We have cases that are taking 3 or 4 months, and just recently the Department of Labor mentioned that they're trying to get the processing time down to under 60 days for most labor certification cases.
Jim, if I could just interject there. Yeah, although at the moment labor certifications are more predictable than the priority worker petitions that you're discussing, about the time we start relying on a time frame, the Department of Labor sometimes decides not to work for a few months, and suddenly what was taking, when they first started this current system, you could get one done like in a week sometimes, and then next thing we knew it was 6 months. But I agree with you that currently it seems reasonably stable that within a couple months you can get a labor certification unless you get unlucky and run into a roadblock, whereas the direct petitions for priority workers that Jim's talking about are considerably more unpredictable in result. As he's mentioned, the government agency has displayed some hostility to these that doesn't seem to be very good policy as a national policy.
Right, and that's correct. When you're projecting processing times, it's always unpredictable, and over the past, say, 15 years, the labor certification processing time has been a month. It's been 5 years, and it's back down to a few months in the future. Who knows? So avoiding a labor certification can be one of the considerations. But one of the advantages of labor certification is that you have a pretty predictable outcome. Probably more than 85% of the labor certifications filed are approved. And when you get to scientists and engineers and people who are clearly in short supply, I wouldn't be surprised if the approval rate was above 95%. Contrast that to extraordinary ability petitions or national interest waiver cases. The national interest waiver cases for many years were hovering around 50% approval rate, and I think there is less certainty there. So one of the things you want to look at is labor certification. You want to have a very clear idea of why you're using the priority worker category. And let's start with the two EB1 categories that we're going to talk about today. Extraordinary ability, people who are at the very top of their field, and outstanding professor and researchers. These EB1 categories are great for people from India and China, where the EB2 category is currently backlogged 4 years, recently has been backlogged 5 years. So you can avoid, in addition to the labor certification, you can jump immediately to the immigrant visa petition and then avoid the quota backlog. For someone from any country other than India and China, you have a current EB2 category right now. And of course, that's been different in the past, and it could be different in the future. But right now, it's current. And you really have to think long and hard whether there's a compelling reason not to do the labor certification.
If I could just expand on that a little, Jim. The visa availability date for various employment categories limits when a person can take the final step for their green card. And as you mentioned, for these people from India and China, the EB2 category, although it's current for the rest of the world, for them is now backed up to 2007. So that currently somebody who started a labor certification in November of 2007, actually October 31st and earlier, are the only people who can take the last step. And so for them, as Jim suggested, there's a much bigger incentive to go with one of these alternative priority worker direct petitions because that does not have this 4 or more year wait to actually get the prize at the end.
That's right, Bob. And more importantly, there might be, or not more importantly, but sometimes of equal importance is you have some people who have are using up their 6 years in H1 status and don't have the AC-21 ability to continue that H1 status beyond the 6th year, and in that case they need to file for adjustment of status sooner rather than later. And I'll be talking later about maybe using some of these EB1 categories strategically to get a I-485, an adjustment of status application on file. So those are two reasons for filing these priority worker petitions. Avoidance of the labor certification, avoidance of the China and India quota, and in other years, avoidance of the quota of other countries. There's another good reason for filing two of the categories for the national interest waiver and the EB1 extraordinary ability categories do not require employer sponsorship. So you might have an entrepreneur, you might have someone who is self-employed, or you might have someone who is a top scientist but whose public or semi-public employer has a policy against sponsoring green cards. They might have a temporary postdoc assignment, and they don't have a sponsor who can get them a labor certification or can get them an outstanding researcher petition approved. So that so those self-sponsorship turns out to be a big reason for a lot of these applications. Another possibility, again going back to someone who's running out of time in H1 status, we've had the situation where we've actually filed an adjustment of status based on an EB1 or EB2, EB1 extraordinary ability or EB1 outstanding researcher position. It might not be a strong case. We think it's a strong case, but we also know that the USCIS might not believe it's a strong case. So in those cases where time is running out, we can file the adjustment of status application. Within 90 days, we get employment authorization, and that employment authorization can be a bridge to getting the labor certification approved and a new I-140 on file, which can take the place of, let's say, the outstanding researcher petition. So it's not really a strategic filing. You have to look at whether it can be done in good faith, whether you believe that under the regulations and under the statute that this person meets the criteria for being an outstanding researcher or meets the criteria for being a person of extraordinary ability. And for a person of extraordinary ability, we have two definitions. One is in the statute and one is in the regulations. The definition in the statute is someone who has sustained national and or international acclaim. And acclaim means probably more than recognition. Acclaim, it's from the Latin, it means to shout or to, it's something that is more than just having works cited. Someone has said or will say in your petition that this person is at the top of their field. And that's the definition in the regulation, that it's one of those few individuals who've risen to the very top of their field. That's a very difficult standard for anybody to come up with. And one way to make your case is to first define your field. What is the field that you're talking about? You could say you're the top physicist in the world, or you could say you're the top physicist who deals with a certain subspecialty within physics. And one of the things I like to look at is whether there's a professional journal devoted to that area of science or endeavor. And if there is, can we say that that your client is one of the top people that everyone recognizes, who has written a book or has written articles that people have read in the field. And then when you mention that person's name to someone, say in France, they've at least heard the name, that person is one of the people that you recognize and who've received a recognition for their work that goes beyond mere being cited or being invited to one or two conferences. So one of the factors, and we'll talk about the various factors, but one of the factors is a high salary, but and this might be one of the reasons why you avoid the labor certification, is you don't have to mention salary in an EB1 case. And with the labor certification, a prevailing wage, might be